Is there an example you could give on a positive or a negative?
A good example might be somebody that wants to protect their assets and would consider giving everything away, giving it to the children, or doing an outright gift, or even doing a trust that is irrevocable and can't be changed. So that might accomplish certain of their goals, like protecting assets. Okay, and again, it gets a little bit more complicated because there's a certain period of look-back period, and there's also tax consequences. And those are very significant, which I would have a lengthy discussion about the client with. I'm not going to have that discussion with you now. But the point is, of giving an asset away, you are making an irrevocable transfer, so that if you really ever needed the asset for anything, legally, it's not yours. It's gone.
I understand.
And you can't predict the future. You don't know what's going to happen to the child. You know, God forbid a transfer is made to a child. The child can die. The child can get sued and have creditor issues. The child can get divorced. So, you know, and then beyond that, there's negative, perhaps capital gains tax consequences that I would discuss. So every action that might have a positive aspect, or it could reach the client's potential goal, has some other negative implications that the client needs to understand. And it's very important that an older person and a younger person, that people come with other members of their family to the first meeting or friends, because it helps kind of digest. There's a lot of information to be shared, particularly at the first meeting with any lawyer, and it does help to have somebody with you as a filter.
Some excellent advice and some very complex issues I'm hearing. So that leads us to gifting. How and when does a person really consider gifting? When does it make sense?
You know, it makes sense when, in my view, when a person has enough assets that they gift that they know that they're never going to need those assets. In today's climate, and this gets into a little bit more of estate planning, but in today's climate of low interest rates, there are some very good charitable giving techniques that we can use. There are some interesting type of trusts that we can use to allow you to retain some control for a period of time and then transfer an asset for less than the actual value of the asset. There's also a very positive estate and gift tax climate. The federal law recently changed, and so through 2013, there's a $5 million lifetime exclusion from giving, which we don't know what's going to happen in 2013, but it does, again, the increased exclusion amount, the reunification of the estate and gift tax credit, all of that, plus this low interest rate climate, has really made for a unique time to sort of maybe not gift, but at least explore why it might be the right thing for you. And again, it depends what your situation is, what other assets you have. I'm very cautious and conservative about recommending that clients do that. I look at my job more to present what the pros and cons are as a result of what they're thinking or what they want to do.
What are the risks associated with gifting?
Well, I mean, the risk is that what you've transferred, that you will one day need.
I see. So then what happens?
It's gone.
It's gone.
I mean,
it's
if you
not yours.
relied on your child to be there to give it back to you, there's no legal obligation for them to do that. And even if maybe they wanted to, perhaps they're not in a position to do it because they've been sued, they've died, they've gotten divorced, and it's been the subject, you know, from a creditor action. So it's, you know, I think it needs to be thought through. Wealthy clients, it's less of an issue. But, you know, it's interesting, Leslie, the generations are different. You know, the greatest generation, very conservative, and they hold their assets very conservatively, and they gift. They're more conservative about gifting, and sort of the generation below that might kind of think about it and do it more. The boomer generation is definitely, they want to enjoy their wealth, but they do want to think about preserving it to minimize taxes and to protect it for the next generation. I mean, it's just a generalization, but as I found, the older generation is definitely more conservative about gifting.
It shows the importance of having good counsel.
Yes. I mean, and I maybe should have told you earlier, counsel needs to be a good fit with the family. And so people should talk to their friends and their neighbors and their accountant and get names of people that these people have worked with, that these people trust. And they shouldn't hesitate to interview one or two people to see what the right fit for the family is. Because you could have 3 good lawyers and specialize in this area, and one just might be a better fit with the family than another.
I understand. So if a boomer calls you and they say, I have an elderly parent and we want to come see you, who do you represent? Do you represent the boomer or do you represent the parent?
So great question.
And what are the ethical issues involved?
It's a serious problem, and there are significant ethical issues. You can represent the child in his or her capacity as how they're representing the parent. So for example, if they're a power of attorney, an agent for the parent, you can represent them as an agent. Or if they're a trustee, you could represent them as a trustee, or an executor as an executor. But oftentimes you'll get a call from the child who's a caregiver for the parent, and it was a very trusted child, and they're calling because their parent isn't well, but has capacity. And my job is to represent the parent. That's who your client is. And so the parent has to give you authorization to communicate with the child, and they do. And we have at the first meeting, they'll just sign and, allow us to communicate with the child. But there is. And then, you might have other children in a family calling to say, oh, you met with my mother or my father, and, and you don't, the mother or the father, that's the client. That's who your job is to represent and protect. And and I explain that up front. And then,
is that difficult?
No, not at all. I mean, I think it's important that the family understand that.
What about if the parent is a veteran? Do you see a lot of that?
It's really is a growing area and subspecialty in elder law. There is tremendous access to veteran benefits in the right situations, and if you have a certain level of service, and it is very complicated. And you'll notice in many cities and towns, I think it's a requirement by law to have a veterans administrator. And often they can be a good resource, initial resource about accessing information about the elder citizens' service and what they might be entitled to from veterans benefits. And there's a whole range of benefits, from veterans nursing home to income and even drugs.
We have that in Andover.
Yes, in Andover has a yes. I think every city and town has to have one, or at least part-time, to have a veterans administrator. Yes.
So, do you find yourself interfacing with that office, or?
No, but going back to one of your earlier questions, in terms of being a reference, we'd say here, call so and so, from whatever city and town people live in.
Excellent. Earlier, you mentioned capacity. Is that something that you typically see and struggle with if a family comes to you? Do you see issues of capacity, or perhaps Alzheimer's, and have to make very difficult decisions as a result?
Yes. It can be a difficult time. Often you'll get a call from a family maybe too late. The parent doesn't have capacity, so you can't do some of these things that we've been talking about. And then there are times when a child will tell you that the parent was diagnosed as beginning stages of Alzheimer's or, some form of dementia, and they might have capacity sometimes and not have capacity other times, and the legal requirements for capacity are different for different documents. For executing a deed might be different for executing a will, might be different from executing a power of attorney or a healthcare proxy. And there have been times that I've had to have the client have a geriatric psychiatric evaluation so that I knew that they had capacity either to execute a will or to make a gift. So it can be difficult.
When you say that, do they take offense?
It depends on the person sometimes, and sometimes not. It's not easy
can't imagine.
to get old, and especially when you've lived your life and you've been independent. It could be a difficult time for people. But if they wanted, I think you try to explain as best you can if this is what you want to accomplish, and there's a question of capacity. You're helping them really accomplish what they want by doing it, by affirming that the capacity does exist through a geriatric psychiatrist.
It's great that we have these resources that families can go to.
Yeah, and I'd venture to say, although I don't have the data, that it seems that it is an area of specialty that I would hope is growing, because it seems that the field of geriatric physicians or psychiatry is too small for what the need is right now. I guess
I'm sure.
The demand is greater than the supply.